let you speak. I rise to speak to new clause 74 in the name of my right honourable friend from Sheffield Heeley, who I pay tribute to. The backbenchers are very lucky to have her. But may I also pay tribute to Mr. B, whose story she so movingly told. Now, this campaign to redress the power imbalance to those offered non-disclosure agreements in cases of sexual harassment, bullying and discrimination has been many years in the making. It transcends organisations and it transcends party. And I want to pay tribute to members past and present of all colours who have been a part of this campaign for so long. I was pleased to hear from the Minister from the dispatch box that we hope to continue to make progress, but I hope to urge him to go further, faster, for very good reason, because it's long past time that this just stopped. And I want to start by revealing a never-before-told story, another one from ITN. Now, never before revealed, of course, because it's covered by a non-disclosure agreement, which means I will be using privilege to reveal the details of it. And before I begin, it's worth saying the victim is not alone in this. There have been others from ITN. We've heard one today. I understand there are 7 out there, and there have been investigations done by ITN's board itself who are intent on change. And this victim is very clear. She doesn't want to cause them problems, but she wants MPs to understand the effect this continues to have on her life and why we need to act quickly. So this young woman was in her mid-20s when she landed her dream job at ITN. She quickly became trapped in what we understand to be a coercive, controlling sexual relationship with an older male editor. He would hurl wild accusations at her and accuse her of affairs with colleagues. She ended up suffering with panic attacks as a result of the relationship, and before Christmas 2019, she finally had the courage to end it. And when she returned in January, she was demoted, and her hours reduced, and so was her pay. The first editor, she told, warned her to stay silent. She said, "You don't want to be one of those women who always moan about being wronged." She then confided in a more senior editor, and things got worse. She told her, "It's not like he ever hit you. It's not like you ever had to go to A&E with broken bones." And she returned to work every day for the next year. It took them months to agree to an HR investigation into what happened, and they only agreed on the condition that she would also be investigated. HR found they couldn't assess the complaint as it was criminal in nature, but at the same time found them to be unfounded. Well, that makes no sense. And it was around this time that she raised a question at an ITN Women Empowerment Forum in front of all staff. This was during the pandemic, and she simply asked the question, what support is there for women who report alleged sexual harassment in the workplace? Within an hour, her email was cut off. HR summoned her to an urgent meeting. Her primary offence, it would seem, was asking for help. And from that moment, she was suspended without pay. Now, she'd been completely cut off from almost all support networks for about a year. ITN told her that she wasn't allowed to tell anyone except the police, to be fair, what was happening. But even her best friend had to sign an NDA to attend a meeting to support her. The NHS offered her group therapy for her anxiety. She felt she had to decline because the organisation insisted she stayed silent. And her lawyer said the organisation was trying to starve her out to negotiations over her exit. This took years. By the time we got to the settlement, she'd already racked up £70,000 worth of legal fees. I will, of course.
I know from experience that is in fact one of the practices of employment lawyers who work for employers to go onto Google Maps and look at the houses in which the complainants live so that they can assess what level of assets they are likely to have and whether they are likely to be able to afford to continue their defence to tribunal and or whether or not they could be offered a smaller amount of settlement. Does she agree with me that NDAs are providing cover for this?
So much for her intervention. And yes, absolutely. This is exactly the kind of behaviour that we need to just put to a stop. So she did eventually reach such a settlement, but it was extremely one-sided, and she panicked because the NDA didn't just gag her, but also her partner, her best friends, and her parents, and not the men or the senior execs involved in the harassment that she'd faced. It didn't just cover business matters, and it's worth saying, we are not seeking to stop confidentiality agreements when it comes to business matters. That is not what we're seeking to do here. But what it did cover was everything painful she had endured. Her mental health spiraled and she ended up in hospital. And every day she was in a hospital bed, the lawyers sent her automatic reminders to sign her NDA. So this was a woman at her most vulnerable. It is entirely wrong that she's been put in that position. And it's worth saying, almost none of that NDA is enforceable. If it was actually taken to court, it would fail. And what's in the Victims' Bill makes it clear that she should be able to have got that support. But the fact, we are kidding ourselves if we think these aren't still being used and still being issued. They are. And that is why we need, on the face of this bill, whether it's now or in the Lords or wherever, we need to put a stop to it now. Now, many years on, following an investigation into the treatment of these workers at ITN, she does believe that that organisation is trying to change, and she's grateful to those executives from within who are pushing for reform. Now, the latest update is that they are willing to renegotiate her NDA, and that is very laudable, but she should never have been put under one in the first place. And those protections should be everywhere. Now, we are facing a weird situation that we've created in this House, because in the Higher Education Freedom of Speech Act, there is provision which was put forward as a Labour amendment, which was then taken on in the Lords by the Conservative then government, that says that these kinds of non-disclosure agreements are not allowed, but only in higher education settings, because that was the scope of that bill. Now, I'm an Oxford MP. How is it making any sense at all that I might have a constituent protected from these kinds of non-disclosure agreements if they work for the university, but if they work for any of the university spin-outs, for example, they're not? We have this problem now. I will, of course.
I thank the member for what is a powerful speech, and I pay tribute to the people who shared their experiences. But does the member also agree with me that the people that we're talking about are people with means and with support networks? And actually, if we don't have these protections, then we don't have protections for the most vulnerable in society, and that's why getting these laws right is so important.
I thank him very much, and they are indeed incredibly brave. And what we're trying to show today is that it's men, women, it's discrimination, it's sexual harassment, and it's ubiquitous, it's happening everywhere, and it's happening now. We are not seeking to try and, silence those. And in fact, if a victim wants one, it even says in this amendment, and it would say it on the face of the bill, that if a victim would want an NDA for whatever reason, that they would be allowed to have it. So what this amendment simply seeks to do is to redress this gap. How is it right that in some establishments, sometime soon, workers will be protected, and in others they aren't? This is the time for the government to sort this out. And what the amendment says is not even exactly how they should do this, but that the protections afforded to all workers anywhere should be the same as those afforded in universities. It says from enactment they've got 6 months to sort it out. That should be plenty of time. Arguably, they should be able to tackle this with something in the Lords, which would then give them a bit of extra time to be able to do this now. And I would urge the Minister to not wait for some other bill or some other time. I welcome the words from the dispatch box. They are meaningful. But I would also urge him to look back, and I appreciate it wasn't this government, it was another one, but we've heard this before. This campaign has transcended party and transcended years, it's transcended parliaments. We're making slow progress, and meanwhile these victims continue to be hurt day after day, and every day that these NDAs endure, which are often in perpetuity, that hurt and that trauma continues. So please, let this be the government in which we put these kinds of abuses of non-disclosure agreements where they belong, in the trash can, and we finally afford the protections that we are about to give to all university workers, to every single employee.
I call Imogen Walker.